I'm excited to introduce to you Faith Harmer. She is the owner, realtor of Faith and Team Real Estate, and she has brought a special guest for us today. She has Michael I. Kling of Kling Law Offices, and I want to touch and highlight on his expertise because this is really important. He is attorney for estate planning, probate, asset protection, elder law, corporate, and tax law matters. It is a privilege to have you both on the show. Thank you so much.
Thank you for having us.
Now, Faith, I know you're excited. You've got some key questions that I think can help us all. I'm just going to let you dive right in with Michael. Thank you.
All right, thank you. Thanks, Mike, so much for joining me.
It's a pleasure, thank you.
I've known Mike Kling for several years. He has handled my own trust for my homes and then also for my rental properties, series LLCs. Today, we want to talk about wills and trusts primarily. Lately, I've been getting a lot of questions from past clients about the difference between wills and trusts, and there's a lot of misunderstanding there. Most people think that a will is going to transfer their property at their death, no problem. And when you explain the difference between the two, most of the time they're pretty shocked. So I was happy to have you on the show so that you can explain the difference for everyone.
I get that question all of the time. People will say, oh, Mike, I want to go ahead and do a will. And I said, okay, let's talk about what your goals and desires are. And they generally want to avoid probate. And I say, do you understand that a will only governs assets that are subject to probate? A will does not avoid probate. And they go, well, I thought it controlled my desires upon my death. And I said, it does, but the will has to be executed in accordance with testamentary capacity, as well as in accordance with the statute of wills, which requires witnesses and a notary. As opposed to a living trust is done during lifetime, and it would convey property during lifetime as opposed to death, and a living trust avoids the probate process.
Yes, so when I explain it, it's much simpler. If you have a will.
I can interject. A little estate planning sense of humor says where there's a will, there's a probate. Not a will, there's a way. There's a will, there's a probate. So
absolutely. And that's when people mostly get shocked when I say if it's a will, it's going to go into probate. It's going to cost your loved one a lot more money and a lot more headache and hassle to go through that process rather than having your trust done up front, and then everything that you want to happen to your assets and your property is actually going to happen.
The most important thing about having a living trust is making sure that it is funded correctly, so you will avoid probate. Because if you just have a document without it being properly funded, so you own your house, and you own your house in your individual name, you haven't titled it correctly, and so therefore if you pass, it still would be subject to probate. So what people need to make sure that they understand is once they create a trust, the process isn't finished, that they need to then take title of their assets in the trust to get the benefits of the trust.
Yes. Another really interesting process is something that's fairly new here in the state of Nevada, according to you, because you explained all this to me not so long ago, is a deed upon death. So explain to us what that is all about.
It is new in Nevada. Arizona was the first state to create that statute. And what happened is, as you're aware, Arizona is a retirement community. And what happened is mainly retirees have two primary assets. They have their house and they have a retirement account. Retirement accounts generally pass to beneficiaries via beneficiary designation. So they're having all of these probates over houses. And the problem with trying to create a testamentary transfer without the formalities of a will is it didn't have the witnesses or the notary, so it was invalid. So Arizona created a statute that says you can do a deed upon death, revocable during lifetime. So if you want to sell your house, you can, but upon your passing, the beneficiary, as named in the deed upon death, passes to the title passes to that beneficiary upon them filing an affidavit with the county. Nevada, because it's not going to be outdone by Arizona, right, created the same statute. So we have that in place. So we can now, if the main asset of the person is a house, they can do a deed upon death, and it avoids the probate process.
Great. Another interesting thing that we had talked about is, let's say someone holds title in their name only. They're divorced. They have a minor child. They pass away. The home would go to their next heir, which would be the minor child, but the ex-wife would be the one basically overseeing it, correct?
Correct. So I always ask people if they have an estate plan, and a lot of people go, oh, I have not done one. I said, well, you actually have, but guess who's drafted it for you? The state of Nevada. I said, now, of course you're comfortable with that, right? The state's always looking out for your best interest.
Right.
People look at me like I'm crazy. Yeah, okay, that is a crazy comment. But same thing happens. So what happens is if I don't have a valid testamentary disposition, whether it's my will or my trust, and I pass, it will pass to my heirs. If I'm a single parent and my heir is my child, they will get that through the probate process. However, if my child is a minor by definition is incapacitated, they do not have capacity to hold title, a guardian would have to be appointed. That guardian then has control of the assets until that child turns the age of 18, which I think is interesting because then you say, of course you want your child to have unbridled access at age 18, don't you?
Right.
Oh, my child's fantastic. Most of the time.
Most of the time. Then the last subject I wanted to talk about is guardianships, because I'm experiencing that with a client right now. And for him, it's a complete nightmare. He's in another state. He got guardianship of her because she has poor health, but she has a home here. They got the guardianship in another state, came here to sell it, and they said, that has to be a special document completed here in Nevada, and it's taking him months and months, and he's still not there.
Yeah, and that's the problem when you have states in multiple jurisdictions. Each state controls that property. So even though there's a guardian appointed in another state, Nevada says the property's here. That's a guardian in another state, so you need to have a formal process here. That's one of the benefits of a living trust, that not only would it avoid probate, it would avoid the need of the guardian as well, because title's in the name of the trust. If the settlor becomes incapacitated, a successor trustee steps into their shoes in a fiduciary capacity, so they can't just abscond with the funds, but then it avoids the need of court intervention.
Yeah, that's great. So there's some great subjects to talk about that affect so many people, and typically as a real estate agent, I get them after the fact, and then we try to wade through the whole process, and it can be very, very difficult. So, well, thank you so much again for joining me to share all these tips with everyone. If you would like to reach out to Mike, you can reach him at
Mike at KlingLawOffices.com or 702-304-1561.
And if you need to buy or sell a home, you can reach me at 702-493-9608. And remember, whether buying or selling, you got to have faith. Back to you.
Faith, Michael, thank you so much. Incredible information. So great to have you on the show today. Thank you.
Thank you.
Thank you.
You're watching The American Dream.